This is a video reviewer for the Philippine Bar Examination. This is Bar Exam Reviewer number 2, featuring questions on criminal law, felonies. There are 10 questions featured in this reviewer. All questions are modeled on actual questions that appeared on previous Philippine bar exams. Before you proceed, please don't forget to subscribe to Review Central and click the bell icon to make sure you are notified of all new reviewers and other important updates. Let's begin.
Question number 1. Juan and Arturo devised a plan to murder Joel. In a narrow alley near Joel's house, Juan will hide behind the big lamppost and shoot Joel when the latter passes through on his way to work. Arturo will come from the other end of the alley and simultaneously shoot Joel from behind. On the appointed day, Arturo was apprehended by the authorities before reaching the alley. When Juan shot Joel as planned, he was unaware that Arturo was arrested earlier. Discuss the criminal liability of Arturo, if any. Note: this question is known to have appeared in the 1998 bar exam. Suggested answer: Arturo, being one of the two who devised the plan to murder Joel, thereby becomes a co-principal by direct conspiracy. What is needed only is an overt act, and both will incur criminal liability. Arturo's liability as a conspirator arose from his participation in jointly devising the criminal plan with Juan to kill Joel. And it was pursuant to that conspiracy that Juan killed Joel. The conspiracy here is actual, not by inference only. The overt act was done pursuant to that conspiracy whereof Arturo is co-conspirator. There being a conspiracy, the act of one is the act of all. Arturo, therefore, should be liable as a co-conspirator, but the penalty on him may be that of an accomplice only. People v. Niera, 96 Iskra 1, People v. Medrano, 114 Iskra 335, because he was not able to actually participate in the shooting of Joel, having been apprehended before reaching the place where the crime was committed. Here's an alternative suggested answer. It actually has the same conclusion as the previous suggested answer, but with slightly different details and presentation. Arturo's criminal liability can be analyzed based on several key principles. Conspiracy. According to Article 8 of the Revised Penal Code, conspiracy exists when two or more people agree to commit a crime and decide to commit it. Arturo, having agreed with Juan to murder Joel, is liable for conspiracy to commit murder. The fact that Arturo was apprehended before reaching the crime scene does not negate his liability for conspiracy. Attempt. An attempt to commit a crime is defined as any act which is a direct step towards the commission of the crime but is not yet completed. Since Arturo was apprehended before he could actually shoot Joel, he did not complete the act of murder. However, his actions toward reaching the alley with the intent to shoot Joel could be considered an attempt, which is punishable under Article 6 of the Revised Penal Code. Criminal liability for the completed crime. Although Arturo did not personally commit the murder, he is still criminally liable for the act of murder committed by Juan due to their conspiracy. All participants in a conspiracy can be held liable for the criminal acts performed by any of the conspirators in furtherance of the conspiracy. Thus, Arturo is criminally liable for 1. Conspiracy to commit murder. His agreement and plan with Juan to murder Joel constitute conspiracy. 2. Attempt to commit murder. Depending on how far Arturo's actions progress towards committing the crime, he may also be liable for the attempt. And 3. The specific charges would be determined by the court based on the details of Arturo's involvement and actions.
Question number 2. Are there common law crimes in our jurisdiction? Note: this question is known to have appeared in the 1988 bar exam. Before we give you the suggested answer, let us quickly review what common law is. Common law is a legal system that is based on court decisions, or precedents, instead of statutes or codes. It originated in England during the Middle Ages and is also known as Anglo-American law. Today, the United States, Canada, India, and Australia are among the countries that still use common law. And now to answer the question, here are a couple of suggested answers that you may consider. 1. There are none. The rule is:
Nullum crimen. Nulla poena sine lege.
there is no crime if there is no law punishing it. Or,
Nullum poena sine lege.
no punishment without law. 2. There are no common law crimes in the Philippines. No act shall constitute as a crime unless it is made so by law. U.S. v. Taylor, 28 Phil 599. Also, from Article 5 of the Revised Penal Code. If there is no law punishing the act or omission, the court must dismiss the case no matter how wicked the act may seem.
Question number 3. A, B, C and D, all armed with armalites, proceeded to the house of X. Y, a neighbor of X, who happened to be passing by, pointed to the 4 culprits the room that X occupied. The 4 culprits peppered the room with bullets. Unsatisfied, A even threw a hand grenade that totally destroyed X's room. However, unknown to the 4 culprits, X was not inside the room and nobody was hit or injured during the incident. Are A, B, C and D liable for any crime? Explain. Note: this question is known to have appeared in the 2000 bar exam. Suggested answer: yes. A, B, C, and D are liable for destructive arson because of the destruction of the room of X with the use of an explosive, the hand grenade. At first glance this case appears to be an impossible crime, but liability for an impossible crime is to be imposed only if the act committed would not constitute any other crime under the revised penal code. Although the facts involved are parallel to the case of Implied v. Court of Appeals, 215 Iskra 52, where it was ruled that the liability of the offender was for an impossible crime, no hand grenade was used in said case. The use of hand grenade resulting to the destruction of X's room constitutes a more serious crime though different from what was intended.
Question number 4. Distinguish, in their respective concepts and legal implications, between crimes mala in se and crimes mala prohibita. Note: this is another bar exam favorite. It is known to have appeared in several bar exams, including but not limited to the 1997, 1999, 2001, 2003, and 2005 bar exams. There have also been several other questions related to either or both mala in se and mala prohibita. The above question may have been stated differently in different bar exams, such as: briefly state what essentially distinguishes a crime mala prohibita from a crime mala in se. Or, distinguish between crimes mala in se and crimes mala prohibita. Or simply, distinguish mala in se from mala prohibita. And so on. Suggested answer: in concept, crimes mala in se are those where the acts or omissions penalized are inherently bad, evil, or wrong that they are almost universally condemned. Crimes mala prohibita are those where the acts penalized are not inherently bad, evil, or wrong but prohibited by law for public good, public welfare or interest, and whoever violates the prohibition are penalized. In legal implications: in crimes mala in se, good faith or lack of criminal intent or negligence is a defense, while in crimes mala prohibita, good faith or lack of criminal intent or malice is not a defense. It is enough that the prohibition was voluntarily violated. Also, criminal liability is generally incurred in crimes mala in se even when the crime is only attempted or frustrated, while in crimes mala prohibita, criminal liability is generally incurred only when the crime is consummated. Moreover, in crimes mala in se, mitigating and aggravating circumstances are appreciated in imposing the penalties, while in crimes mala prohibita, such circumstances are not appreciated unless the special law has adopted the scheme or scale of penalties under the revised penal code.
Question number 5. Alexander, an escaped convict, ran amok on board a Superlinees bus bound for Manila from Bicol and killed 10 persons. Terrified by the incident, Carol and Benjamin, who are passengers of the bus, jumped out of the window and while lying unconscious after hitting the pavement of the road, were ran over and crushed to death by a fast-moving Desert Fox bus tailing the Superlinees bus. Can Alexander be held liable for the death of Carol and Benjamin although he was completely unaware that the two jumped out of the bus? Explain. Note: this question is known to have appeared in the 1996 bar exam. Suggested answer: yes, Alexander can be held liable for the death of Carol and Benjamin because of felonious act of running amok was the proximate cause of the death of victims. The rule is that when a person, by a felonious act, generates in the mind of another a sense of imminent danger, prompting the latter to escape from or avoid such danger and in the process, sustains injuries or dies, The person committing the felonious act is responsible for such injuries or death. U.S. v. Valdez, 41 Phil, 1497, and People v. Apra, 27 Iskra 1037.
Question number 6. Distinguish motive from intent. When is motive relevant to prove a case? When is it not necessary to be established? Explain. Note: this question is known to have appeared in the 1999, 2004, and possibly other bar exams. Suggested answer. Motive is the moving power which impels a person to do an act for a definite result, while intent is the purpose for using a particular means to bring about a desired result. Motive is not an element of a crime, but intent is an element of intentional crimes. Motive, if attending a crime, always precede the intent. Motive is relevant to prove a case when there is doubt as to the identity of the offender, or when the act committed gives rise to variant crimes, and there is the need to determine the proper crime to be imputed to the offender. Conversely, it is not necessary to prove motive when the offender is positively identified, or the criminal act did not give rise to variant crimes.
Question number 7. During the robbery in a dwelling house, one of the culprits happened to fire his gun upward in the ceiling without meaning to kill anyone. The owner of the house who was hiding thereat was hit and killed as a result. The defense theorized that the killing was a mere accident and was not perpetrated in connection with, or for purposes of, the robbery. Will you sustain the defense? Why? Note: this question is known to have appeared in the 1999 bar exam. Suggested answer. No, I will not sustain the defense. The act being felonious and the proximate cause of the victim's death, the offender is liable therefore, although it may not be intended or different from what he intended. The offender shall be prosecuted for the composite crime of robbery with homicide, whether the killing was intentional or accidental, as long as the killing was on occasion of the robbery.
Question number 8. State the concept of implied conspiracy and give its legal effects. Note: this question is known to have appeared in the 1998 and 2003 bar exams. Suggested answer. An implied conspiracy is one which is only inferred or deduced from the manner the participants in the commission of crime carried out its execution. Where the offenders acted in concert in the commission of the crime, meaning that their acts are coordinated or synchronized in a way indicative that they are pursuing a common criminal objective, they shall be deemed to be acting in a real conspiracy, and not just implied conspiracy, and their criminal liability shall be collective, not individual. The legal effects of an implied conspiracy are: A. Not all those who are present at the scene of the crime will be considered conspirators. B. Only those who participated by criminal acts in the commission of the crime will be considered as co-conspirators, and C. Mere acquiescence to or approval of the commission of the crime, without any act of criminal participation, shall not render one criminally liable as co-conspirators.
Question number 9. Mr. Carlos Gabi C., a customs guard, and Mr. Rico Ito, a private individual, went to the office of Mr. Dither, a customs broker, and represented themselves as agents of Moonglow Commercial Trading, an importer of children's clothes and toys. Mr. Gabi C. and Mr. Ito engaged Mr. Aquardo to prepare and file with the Bureau of Customs the necessary import entry and internal revenue declaration covering Moonglow's shipment. Mr. Gabi C. and Mr. Ito submitted to Mr. Aquardo a packing list, a commercial invoice, a bill of lading and a sworn import duty declaration which declared the shipment as children's toys, the taxes and duties of which were computed at 60,000 pesos. Mr. Aquardo filed the aforementioned documents with the Manila International Container Port. However, before the shipment was released, a spot check was conducted by Customs Senior Agent James Bondito, who discovered that the contents of the van, or shipment, were not children's toys as declared in the shipping documents but 1,000 units of video cassette recorders with taxes and duties computed at 600,000 pesos. A hold order and warrant of seizure and detention were then issued by the District Collector of Customs. Further investigation showed that Moonglow is non-existent. Consequently, Mr. Gabi C. and Mr. Ito were charged with and convicted for violation of Section 3E of Republic Act 3019, which makes it unlawful, among others, for public officers to cause any undue injury to any party, including the government, in the discharge of official functions through manifest partiality, evident bad faith, or gross inexcusable negligence. In their motion for reconsideration, the accused alleged that the decision was erroneous because the crime was not consummated but was only at an attempted stage, and that in fact the government did not suffer any undue injury. A. Is the contention of both accused correct? Explain. B. Assuming that the attempted or frustrated stage of the violation charged is not punishable, may the accused be nevertheless convicted for an offense punished by the revised penal code under the facts of the case? Explain. Note: this very long criminal law case question is known to have appeared in the 2000 bar exam. Suggested answer. A. Yes, the contention of the accused that the crime was not consummated is correct. Republic Act 3019 is a special law punishing acts mala prohibita. As a rule, attempted violation of a special law is not punished. Actual injury is required. B. Yes, both are liable for attempted estafa through falsification of commercial documents, a complex crime.
Question number 10. What is an impossible crime? Is an impossible crime really a crime? Note: this question is known to have appeared in the 2000 bar exam. Suggested answer. An impossible crime is an act which would be an offense against person or property, were it not for the inherent impossibility of its accomplishment or on account of the employment of inadequate or ineffectual means. Article 4, Paragraph 2 of the Revised Penal Code. An impossible crime is not really a crime. It is only so called because the act gives rise to criminal liability. But actually, no felony is committed. The accused is to be punished for his criminal tendency or propensity although no crime was committed.
References and attributions. The questions featured in the preceding reviewer were adopted from two documents, namely: 1. Answers to bar examination questions in criminal law arranged by topic, 1975 to 2003, edited and arranged by Jeanette Logie E. Cow and Alex Andrew P. E. Cow, Silliman University College of Law, which in turn was based from the answers to bar examination questions in criminal law by the UP Law Complex, July 26, 2005. And 2. Answers to bar examination questions in criminal law arranged by topic, 1994 to 2006, version 1973 to 2003, edited and arranged by Jeanette Logie E. Cow and Alex Andrew P. E. Cow, Silliman University College of Law, and updated by Don D., which in turn is based from the answers to bar examination questions in criminal law by the UP Law Complex and Philippine Association of Law Schools, July 3, 2007. Both documents have been expressly declared as freeware by their creators. This reviewer has been prepared and presented by Review Central solely and entirely for educational and reference purposes. No copyright infringement intended.
You have just watched the Philippine Bar Examination, Reviewer Number 2, featuring questions on criminal law, felonies. Check out more related review videos and playlists on our channel. If you find this useful, please like and share. Leave a comment to share your thoughts or questions regarding this reviewer or any particular part of it. If you haven't done so yet, please subscribe to Review Central and click the bell button to get notified of all future reviewers and updates. Like and follow us on your favorite social media platforms. Good luck to your forthcoming bar exam, and we look forward to your long and fulfilling career as a lawyer and legal professional in the Philippines.